welcome on behalf of the Constitution Society, and thank you for finding the time to be here this evening for the launch of our report on Judicial Review and the Rule of Law, written by Amy Street. Amy is a barrister and the Society's research director. The last paper she co-authored for us, which was on Select Committee Powers, was commended in the Commons by no lesser a figure than the Shadow Chancellor. And I hope this very important report will be similarly influential. Bill Cash has to go and vote at 7, so he's actually going to speak first before Amy. Bill is the Conservative MP for Stone in Staffordshire, best known as perhaps the leading Eurosceptic in the Commons, but also a former Shadow Attorney General. After that, Amy will present her paper. Then we have our two remaining speakers, Konrad Schiemann on my right, a former Lord Justice of Appeal who served as the British judge on the European Court of Justice until 2012. And secondly, Richard Gordon, one of the leading silks practicing in the area of public and constitutional law, and a member of the Constitution Society's Advisory Board. Our fifth speaker, Graham Allen MP, is unfortunately ill and sends his apologies, but given the size of this table, that may be no bad thing. The speakers' presentations will take a little bit under an hour. Bill will hopefully be back before the end of that, and with the speakers' permissions, we will be recording their contributions. But when we throw it open to the floor, we'll switch the cameras off, and it will be under the Chatham House rule. Well, the background to Amy's paper is the government proposal set out in a consultation paper in September to reform some aspects of the judicial review process, in particular to restrict the categories of person who may bring a claim. And there's been a good deal of discussion, especially in the legal profession, I suppose, about the likely effect of the government's plans and the appropriate balance between protecting rights on the one hand and the efficient administration of justice on the other. So far, the debate has perhaps not sufficiently focused on the potential constitutional consequences if some of these changes are implemented. Their impact on the rule of law, the constitutional balance of power generally, and indeed the possibility of a confrontation between Parliament and the judiciary. And having read Amy's paper, I do not believe that is a merely hypothetical danger. So this is a very timely report, and I'd strongly recommend you to read it, or at least the very clear executive summary. So given Bill's timing, let me stop there and ask you to take it up.
Thank you very much indeed. Do we switch these things on, or are they on already?
I think they're on already.
Okay. Because of the time factor, and I apologise, but on the basis that Parliament is supreme, I have to return, or at least the whips are supreme in terms of Parliament, except when I feel that they're not. But having said, like this afternoon, but having said that, I've got to concentrate for the purpose on making it as short as possible. We can return to the debate later, but what I would like to say, first of all, is I found Amy's paper extremely interesting. I really feel that I have to reply to parts of it, though, quite strongly, and in particular to invoke Tom Bingham's Chapter 12 of the Rule of Law and the Sovereignty of Parliament, because she quite rightly poses a number of questions which actually he deals with in Chapter 12 as well. And so to get straight to the point in view of the lack of time, I would say that he says, because Amy argues that the question of whether or not Parliament is effectively supreme in terms of judicial review is a very crucial question, and I recognise that, and I have seen what Lord Stayne has said and Lord Hope and so on. So from that point of view, I agree that it is out there, but I would only say this, that I'm very much a Tom Bingham man, and he says here, reflecting this view, that's the view that she's expressed, as being open to serious consideration, some distinguished academic authors and some judges in extrajudicial utterances and obiter observations have suggested that Parliament is not or is no longer supreme, and that in some circumstances the judges might, without the authority of Parliament, hold a statute to be invalid and of no effect because contrary to a higher fundamental law or to the rule of law itself. And he dismisses that view completely, and in fact is quite critical of some of the Supreme Court judges who ventured into that territory. I would also quote, he quotes an extremely important book which we used in our European Scrutiny Committee inquiry into parliamentary sovereignty by Galsworthy, which I shall simply leave on the table. He describes it as magisterial. But he also, this is Tom Bingham again, goes on to say, regarding the principle of parliamentary sovereignty, what the principle means is that Parliament has in the United Kingdom no legislative superior. The courts have no inherent powers to invalidate, strike down, supersede or disregard the provisions of an unambiguous statute duly enacted by the Queen in Parliament, and indeed an extremely limited power to inquire whether a statute has been duly enacted. He then deals with Bonham's case of 1610 and says, well, frankly, we're not at all sure what he thought he was saying at the time. In fact, he got dismissed from his job for having got it wrong. And then he concludes by saying at the end, to substitute the sovereignty of a codified and entrenched constitution, which would be the other way of going about it, of course, for the sovereignty of Parliament is, however, a major constitutional change. It is one which should be made only and if the people, properly informed, chose to make it. Well, I'm now not going to get into a dissertation about the European referendum in or out, but it does contain elements of that debate. The reason I'm mentioning this is because I think it's at the heart of this question, and I also happen today to have had an urgent question on this very issue, which I had to put to, or wanted to put, and was granted by the Speaker permission to put, to the House of Commons and to the Justice Secretary, who happens also to be Lord Chancellor, in that order. And I made the point that Mr. Justice Mostyn's obiter in the case that he dealt with on the 7th of November, which he described in terms of the European Court decision on which it was based, as being one of such constitutional significance as it can hardly be overstated. What did it do? We passed the Lisbon Treaty through the European Union Amendment Act in 2008. It contains what, by common consent, was thought to be a complete exemption from the Charter of Fundamental Rights. In fact, the European Scrutiny Committee, of which I may say Speaker's Counsel now, Michael Carpenter, who's here today, was then our legal advisor, and some of us who take an active interest in these were actually quite worried about the wording, and we expressed that in our report. However, the government made its own judgment, and it said that it was valid and it would hold water. Now, what's happened is that Lord Justice Mostyn, Mr. Justice Mostyn, has now thrown serious doubt on that, and as I put it this afternoon, is likely to open the floodgates to a lot of other applications that the Charter of Fundamental Rights, which includes the right to strike, collective bargaining, a whole range of other matters which we had assumed and which the Labour government previously had assumed would not apply. What is the relevance of this to this debate we're having today? Very simple. Because when the European Court decision, which was made, was invoked by Mr. Justice Mostyn, Sections 2 and 3 of the European Communities Act come into play. And it's an obligation which I suspect, actually, the Supreme Court may well turn out to have to go along with. Mostyn is right, and that therefore they have no option other than to say that that part of the European Union Amendment Act, which includes the protocol which grants the exemption for the Charter of Fundamental Rights, has to be struck out. Now, that is very similar to the factor-tame situation, and therefore it does create the potentiality for an extremely interesting debate, but also some very practical consequences. So when I turn to your paper, and I see that you say things in your summary, if I may say, for example, the risk of judicial interpretation, this is on page 46, contrary to Parliament's clear intention, may be all the more conceivable if the government maintains its acting in accordance with the rule of law, and so on. And if the government has stated essentially it doesn't intend to undermine the rule of law, etc., I beg your pardon, you say under a traditional understanding of parliamentary sovereignty, this is page 47, legislation will be applied by the courts and there is no reason to question this most of the time. Thank you. However, there is some judicial support, which I've already dealt with, for the proposition, at least Tom Binger has, that while the supremacy or sovereignty of Parliament is still the general principle of our Constitution, the principle is not absolute. And I think, if I may say with great respect, that perhaps is going a little too far. And because the principle was created by judges, judges could decide not to follow it in certain circumstances, such as an attempt to abolish judicial review. I would simply say, as one who started his legal life in the 1960s in judicial review, it's been growing like topsy, but actually I don't think there's any legislation which says there will be judicial review. It has emerged from the confluence of events, but I really do not believe that it is possible to argue that Parliament is not supreme because, and for this reason, which Tom Bingham doesn't give, but which I adhere to very strongly, that it is based on the will of the people in a democratic in a democratic forum, which is based on general elections. And it doesn't matter to me whether the decisions are taken by the European Court of Justice or whether they are taken by the judiciary. For my money, and I'm giving you a personal opinion, I believe that when Parliament enacts something, that has to be retained in its completeness, and that it would not be right for but for the European Communities Act for the courts to strike it down. Now, I'm not questioning factor-tame, because as Lord Bridge said, it was a voluntary act entered into by the United Kingdom, and so be it. But the question of whether or not it remains there in aspect as a constitutional entity forever is very debatable, and I believe, in fact, I would say the opposite. I would say that if we were to decide to leave the European Union, we could do so, that the courts are not at liberty to simply invade that act, but that I do agree that so long as Section 3 remains, we are obliged, and the Supreme Court would be right if it got to them, to insist that that law has to be applied. But the question then arises, what do you do about the fact that it's in direct conflict with the expressed will of Parliament that the fundamental charter should not apply to the United Kingdom? So you've got a conflict. So actually today is quite a good example of the very essence of your paper. I'd love to go on and talk about other matters, but I thought I'd just put that one on the table because I think basically your paper turns on this proposition that that it is now an open question, as I think you would put it, that Parliament is not supreme, and I don't believe that is I believe it is the case that Parliament is supreme. I agree also with Tom Bingham that there are a lot of absurd arguments that arise about whether or not you can say that a person with red hair has got black hair or whatever it is. I mean, all that kind of nonsense. But actually, right at the heart of it, we're dealing with really big questions of the kinds that arose this afternoon. So forgive me for not being able to go into more detail in these matters, but I did want to get that one right out on the table because I think it's a very interesting paper, but I don't agree with that element of it. There is no uncertainty in my view. I think it's crystal clear and it's based on democratic authority. It's not based on some ideological or constitutional principle.
Thank you very much, Bill. Amy.
Thank you, Nat. Well, I'm glad that my paper has generated some debate, even in a few minutes this evening. But I'm going to go back a step and just explain a summary, really, of what I say in my paper, and then perhaps we can come back to some of those issues once everybody else has spoken. There's vigorous debate about the meaning of the rule of law. So for the purpose of this paper, I've tried to identify a meaning to work with. Our system of judicial review is probably best described as reflecting a version of what some people call a thick understanding of the rule of law rather than a thin one. This is because our system of judicial review judges not merely the form, but also the content of law. So, for example, the government's decisions must be reasonable. Furthermore, the rule of law has a core meaning for the judiciary, because they use it to justify their judicial review jurisdiction. And it's the judiciary's understanding of the rule of law that I've tried to take forward in my paper. Ultimately, it's the judiciary's view that matters, because it falls to them to apply any relevant legislation passed by Parliament. If there's a difference of view about the meaning of the rule of law between the government and Parliament on the one hand and the judiciary on the other, then this might give rise to a disagreement between those two branches of state. And it's the potential for such a disagreement and the consequences that might follow which are the focus of the paper. Turning to the government's reforms, the government has already introduced a first wave of reforms focusing on procedure. But its further reform consultation paper contains a more significant mixture of proposals. Some are directed at streamlining judicial review, and it's in everyone's interests for judicial review to be made more efficient, so long as this is done consistently with how the judiciary understand the rule of law. But others of the suggested reforms go beyond efficiency and aim to restrict the judicial review cases which can be considered by the courts. These more substantive reforms may have significant constitutional implications. In the paper, I highlight 3 key reforms which may have this effect. First, standing, who may bring a judicial review claim. Secondly, restricting the court's ability to examine cases where the government says it's highly likely that acting lawfully would have made no difference to the outcome. And thirdly, restricting the availability of protective costs orders, which limit the costs exposure of a claimant taking a case in the public interest. The first one, standing, is a particularly good example to focus on because the courts have developed a wide test for who can bring a claim precisely so they can uphold the rule of law. The courts allow NGOs and other public interest organisations to bring claims even if they have no direct interest themselves because, in the words of Lord Reid in the Supreme Court, insistence upon a particular interest could prevent the matter being brought before the court, and that in turn might disable the court from performing its function to protect the rule of law. The government is proposing insisting upon a particular interest, which would rule out many claims in the public interest by NGOs and put some unlawful government action beyond the reach of the courts. This is the crux of the matter. What happens if the government introduces its proposals on standing and other issues, and the courts consider that this disables them from performing their function to protect the rule of law? My conclusion is that it would be dangerous to assume that the courts would necessarily, simply and straightforwardly, apply any new legislation with the effect that the government intends. The courts have a well-established track record of refusing to give effect to the clear intention of Parliament to restrict judicial review, and could do so again in extreme circumstances. They've so far done this using principles of what they call interpretation. The judges saying that they're merely interpreting the law as laid down by Parliament. Parliament can't be taken to have intended what it actually said. But in an extreme case, the courts could be asked not to apply a statute altogether. Under a traditional understanding of parliamentary sovereignty, Parliament can pass whatever laws it likes, and these laws must be applied by the judiciary. But some of the senior judiciary, as you've heard, have suggested that they may not apply extreme laws, such as an attempt to abolish judicial review altogether. This is highly controversial, and it doesn't reflect a consensus view from the judiciary. but it may be unwise for the government and Parliament to assume that it is a fixed constitutional arrangement that judges apply whatever laws Parliament passes, however much they may threaten the rule of law as the judiciary understands it. If the judges were triggered to take a stance against extreme judicial review reform, the result could be a constitutional crisis of uncertain effect and proportions. I could conclude by suggesting that there may be three options for the government. First, do nothing, leaving judicial review as it is. Secondly, take forward efficiency-based reforms only, ensuring that these are consistent with the rule of law as understood by the judiciary. Or thirdly, take forward reforms going beyond efficiency. For the reasons I've explained, it may be thought that these proposals need great caution because of their potential to disrupt the current constitutional balance and potentially to trigger a constitutional crisis. Thank you.
Thank you very much, Amy. Konrad.
I'd like to start by congratulating Amy on what seems to me to be an extremely balanced and well-written paper. When you come to read it, I think you will find that it is very well written, and essentially she ends with an open question, saying, well, it's possible that the judiciary will take a different view from Lord Bingham, much as he is admired by everybody. And that seems to me to be a tenable position for her to adopt, and I would, on the whole, though I'm slightly out of touch with the English judiciary now, inclined to agree with the assertion that it's an open question. One can understand, turning to the white paper, for the why ministers get frustrated if their decisions are overruled. Judicial review, overall, in the nature of things, always brings with it cost and delay. That's true even if the judicial review is justified. At times in the white paper you get the impression that the problem is unjustified judicial review, which is of course right. The difficulty on the ground is to know whether the decision being reviewed is or is not illegal. And you do that at the end of the examination rather than at the beginning, and the examination takes time and costs money. The cost of English justice to the litigant is very high compared with most continental systems in any event. And there's no doubt in my experience that some litigants do play the system in order to secure an airing for their political views, even if they're not the views of the decision taker, or to secure delay for a variety of reasons. Delay caused by unsuccessful challenges can destroy the very scheme which is being challenged. This happened in relation to the Opera House, where a scheme was put forward which was challenged by judicial review. I said as a judge of first instance that this didn't stand a ghost of a chance of success. The Court of Appeal disagreed with me. The matter was then argued at first instance by the Court of Appeal and eventually by the House of Lords, who said it was misconceived, the challenge. But by that stage, the financial situation had so completely changed that the plan no longer was capable of being carried forward. Delay can undoubtedly cause substantial public costs, and delay can result in a change of the public mind on a particular topic. When I was at the bar, I put up a series of very thin judicial review challenges myself against the setting up of Shepherd's Market. No, not Shepherd's Market, the market at Shepherd's Bush, sorry, a different place, which has now been there for about 40 years or so, but was refused planning permission, and they went ahead, and there were enforcement notices, and I thought up a whole series of judicial challenges, all of which failed, and finally the local authority triumphed. But then the local authority by this time found that it was so popular that they gave permission for the very thing which had been the subject of all that litigation. This is the sort of thing that happens in real life. So
delay can actually achieve things. But I think the lawyers here have got to understand the problem of the politician. He's got to get re-elected. This requires a majority, and it's easier for him simply to adopt majority views than to seek to change them, especially in the short term. And in order to get elected, he must claim that if he is elected, he will have real power. Otherwise, why should anybody go to the trouble of electing him? And in real life, he just has less power than he is compelled in these circumstances to claim. The country is subject to numerous influences, not subject to easy national control, and partly influences from other countries and the way the market moves and a whole variety of other things. On the other hand, one can quite understand that public demonstration in the courts of the fact that judges can put a stop to a politician's plans must be infuriating for that politician. I understand that entirely. And so the politician is under temptation to do what he can to increase his own power and to neutralize those factors which diminish his power. So one can understand those ministers who say, we must be free to do what we want. We were elected. Bill Cash said in Parliament, one of the greatest freedoms we need to protect is the right to decide our own laws and indeed to ensure that the judiciary complies with the will of Parliament. Pamphlet which he wrote, which has the title, It's the EU, Stupid, he says this, Parliament must override all the so-called provisions which are deemed not to be in our national interest. Parliament is the ultimate authority for the United Kingdom and not the Supreme Court or the Court of Justice of the EU. And that, in substance, is his position, and one can understand it as a position. Now, this tension between elected politicians and unelected judges is not a peculiarly British problem, and yet all civilized nations have a judicial control of governmental decisions in one form or another. Why is this? Firstly, there are from time to time tensions between the interests of the majority as perceived by that majority and the interests of those who are not in the majority. There can be times when the majority is simply not interested in the position of slaves or foreigners or those with a mental handicap or an infectious disease, for instance. And the popular rush is in a particular direction, and all other considerations simply do not play a part in popular discussion. And this can lead the majority to do things which, on reflection, they themselves are not proud of, to put it mildly. History in many countries of the world, including our own, has shown that there can be dangers in allowing those in power to do whatever they want. And most countries have written constitutions which seek to set out guidelines as to what is permissible, by whom, and subject to what modalities. The United Kingdom doesn't. In practice, we've managed by a reasonably common understanding of what is permissible, and by leaving it to the judges to be the ultimate arbiters in cases of dispute. And when you're a judge, you're very conscious of the fact that you are not paid to make decisions on substantive matters. You're equally conscious of the fact that it's sometimes rather difficult to draw the line between making a decision on the substance and upholding the rule of law as you see it, to do right by all manner of men. Now, the judges are deliberately not elected in order to spare them from some of the pressures to which the elected politician is subject. Because the judges are unelected and yet have considerable power, their appointment is subject to prolonged consideration by a variety of bodies and people. At times there are tensions, but we have in this country managed to live with them. The thing which has been done for a long time becomes the done thing in popular imagination. So Parliament, rather than say the Privy Council, has for years been accepted as the ultimate legislative authority and still is. Why is it so accepted? Well, it's always been like that. The top judicial authority, the House of Lords or the Supreme Court, has for years been accepted as controlling the legality of governmental acts, and still is. Why? Well, that's what it does. That's what it's there for. The White Paper does not in terms express any desire to change this situation. One must simply accept that at times this can and will produce tensions. The position in some ways is parallel to that prevailing in the European Union. There can be tensions arising out of the principle of conferral, that the EU institutions only have the powers given to them by member states. Some national courts maintain that it is they who must decide what powers could, under their own constitution, lawfully be transferred to the EU. And they go on to say, logically enough, that powers which couldn't lawfully be transferred were not transferred. Yet, if there is a dispute as to the legality of some EU action, the European Court of Justice has held that it, not any national court, decides that question. Now, there's a problem about who should decide these things, and it's a genuine problem. And the Germans have the phrase competence to capture this tension. I myself think that unresolved tensions have been beneficial to all parties, preventing either side going to unreasonable length. I draw a parallel with a marriage. When getting married, in a way, it would be logical to decide, well, there are only two of us, it's an even number, who's going to prevail when there's a difference of opinion? But very few of us, and certainly not me, sort this out to a logically satisfactory fashion before entering into holy matrimony. And I find that after 48 years or so of being married, there have been tensions from time to time, and the very fact that you want to live together and one's got somehow or other to find an accommodation leads you to find an accommodation. And this, in many ways, is exactly what happens in the European Union. It's exactly what happens in the European Court of Justice when there are differences of view between you and the chap sitting next door, to whom you're going to have to sit next door the following day and the following day and the following day, and somehow or other you've got to work something out. And I think this is actually rather beneficial. And the British Constitution and the rule of law depend on various understandings which have grown up over time. They are vague. There is no clear indication from the White Paper that the government desires to depart from either. Yet there are, as Amy Street sets out in her admirable paper, serious risks that some of the proposals may be regarded by some, at least, of the judges as threatening the rule of law. I personally think that we ought to move very cautiously. It is unfortunate, particularly, if the moves... it is unfortunate that the moves are in the sole control of the very body which is most frustrated by the exercise of judicial review, the government. That's the nature of things. Yet that is the only body which can initiate change. So there's a conundrum there. The best answer that I can give to this conundrum is that there should be the widest possible discussion and consultation before any serious change is made.
Thank you very much, Konrad.
Well, I think we've heard from three excellent speakers tonight, and in a sense they're all saying what I'm going to say, which is A, there is a tension between parliamentary sovereignty and the rule of law. B, but I exclude Bill from this consensus, it needs to be very carefully handled with great circumspection. And C, there is a risk of some form of constitutional collision unless these tensions are managed. what I think we have to realize is that we are here speaking not merely in the abstract, but very much in the particular, which is, of course, the judicial review reform proposals put forward by this government. Now, a minister some years ago, I'm not going to give you his name, is reported to have said, after becoming himself unfortunately entangled in a legal dispute in the courts, "The law is on my side. I know, because I made the law." This may not have to your ears quite the melodramatic chill of Judge Dredd's "I am the law," but it comes pretty close second. I should make it clear, to avoid any doubt, that the minister who said this was a former minister. By a process, therefore, of logical deduction, it was not Chris Grayling. However, I should say that I was reminded of this quote when thinking about the government's recent judicial review proposals. Like the other speakers, I would like to congratulate Amy for producing such an excellent and balanced report. What she makes clear, I think, is that one can sensibly divide these proposals into two distinct halves. Few, I think, and Konrad's made this point very effectively, could deny that greater efficiency is needed when dealing with judicial review. Judicial review lawyers, I've had so much of it recently, can rack up costs to no effect whatever, repeat bad arguments, and generally discredit the system. But anyway, the need for greater efficiency is perhaps what you might call part one of the reforms. Part two, though not designated as such, and sometimes confusingly also couched in the language of efficiency, is different. There are certain proposals which go beyond efficiency and which seek to make real inroads on the current power of the judges to check executive abuse of power. And Amy's paper focuses on standing as well as mentioning protective costs and so forth. In this room, most of us have witnessed the exponential growth of judicial review, and it cannot be doubted that the present government views it with dismay. It is a generic, indeed a Catholic, one may call it, dismay, which captures in its generous embrace virtually the whole of the European Convention on Human Rights, the Strasbourg Court, and most, if not all, of European Union law. But whether as lawyers we might disapprove of this aspect of the reforms may, in constitutional terms, be neither here nor there, or at least neither here nor there as far as the central doctrine of our informal constitution, parliamentary sovereignty, is concerned. Under the bold Dycean awning of parliamentary sovereignty, the government may, it is said, make and unmake any law it chooses. And if that is right, then judicial review cannot be any exception to it. In the short time that I've got left, I want to test that proposition, which is essentially what Bill Cash, I think, is saying, by reference to the central theory by which the judges operate, the rule of law. It is obvious, I suggest, that if Parliament makes the law, then to that extent, Parliament is the law, and the law is therefore inevitably intended to be on Parliament's side. So the former minister got that right. Moreover, as Parliament is, for practical purposes, controlled by the executive, it follows that the law must always be on the government's side. Again, the minister was right. This view, however, inverts a central tenet of the ideal known as the rule of law. Under the rule of law, as Plato put it, and I quote, "Law is the master of the government, and the government is its slave." In that exposition, Plato was perhaps the first exponent of what Amy has pointed us to, the thick version of the rule of law. Some, myself included, might call it the rule of justice rather than the rule of law, because the opposite of the thick version of the rule of law is the thin version of the rule of law, whereby it is sufficient for executive action to conform to the law, provided that it is a law that has been enacted. On that model, of course, Hitler probably conformed to the rule of law because every act of degradation and evil perpetrated by the Nazis was, as Sebastian Haffner reminds us so eloquently in his book, Defying Hitler, accompanied by a meticulously crafted law. But in, as I prefer to call it, the justice model, it is not merely that the government cannot violate the rule of law with impunity, it is that it cannot casually change the law to exempt itself. This is so, surely, because where this version of the rule of law prevails, nobody, not even central government, is above the law. How could it be otherwise if Plato, rather than the minister, got it right, and law is the master of government? In 21st century Britain, though, we need to be very careful how we seek to use abstract concepts, lest they come back to haunt us. Parliamentary sovereignty, I suggest, means something, and yet it means something less than dicey thought. The rule of law means something, and yet it means less than Plato thought. Government cannot get away with everything, but nor can the judges. Both have at different times tended to use phrases such as parliamentary sovereignty and the rule of law as power-sustaining devices. Our modern Western liberal democracy needs, in order to survive, both concepts, just as it needs neither of them in their most absolute articulation. You will remember even tonight Bill Cash talking about parliamentary sovereignty being absolute. Our informal constitution works by what I will no doubt inelegantly call a nod and a wink consensus, Konrad's good marriage. In the more dignified language of HLA Hart, we live by rules of recognition accompanied, accepted by our leading constitutional players. True it may be that in the hierarchical pecking order, Parliament holds the trump card, but most card games, certainly those with trump cards, are not the same thing as solitaire. Grayling may or may not be, but probably is, in tune with the Daily Mail readers in his disrespect for judicial review, Strasbourg and EU law. He may even be in tune with the statistical majority of the populace, which majority would probably still vote in favour of the death penalty. But he is, I fear, not in tune with the majority of the senior judiciary or of the lawyers that play before their courts. If he goes beyond efficiency and tries to dismantle judicial review and our legal aid system, he is placing our constitutional arrangements, haphazard though they are, but workable as they have proved to be, at risk. As Lord Neuberger memorably said a few years ago, you cannot muck about the Constitution. If you do so at your peril. It is this wider constitutional risk that Amy's report addresses, in my view, so persuasively, engaging the possible judicial counterattack to extremism on the part of the government. The judges have always fought back when judicial review is under threat. They are, I believe, likely to do so again if what I've called Part 2 proposals are implemented. This splendid paper shows how even our most tolerant of constitutional arrangements might quickly unravel in those circumstances. That is why the report should be read and reread by those who may have been contemplating such changes with equanimity. Thank you.